Senate Bill 490 modifies the law relating to the whistleblower protection. A few years ago, decade, there was a court case that dramatically changed the way that whistleblower was interpreted in our state. All this does is simply take it back to the way it was. And really what it says is that in order for there to be a whistleblower protection, there actually has to be a finding of something wrong happening. Not this, this threshold that's been created that maybe something might be happening or maybe was going to happen, that there actually had to be something that actually occurred.
All recognize and agree that there should be protections, thank you, afforded to true whistleblowers. And those individuals should not be subject to retaliation and jeopardize their employment for doing that which we all appreciate them doing. That said, we think there needs to be some clarity in the law. And I say we, speaking on behalf of the business community and defense bar, feel there needs to be some clarity in the law. It started out years ago as a narrow exception to the doctrine of employment at will. Over the years, some courts have maintained that it is a narrow exception, and other courts have seemed to expand the exception. And so what we're trying to do is bring it back home and put lawmaking back in the hands of the legislature, as opposed to the courts, and define what this narrow public policy exception is, and specifically tell employers what it is that's protected by this law. With that said, as was just pointed out, one of the key focal points here is that in order for someone to be afforded protection under the law, whether it's because they report something or whether they refuse to engage in certain acts, it actually has to be the reporting of a violation of law and a refusal to engage in a violation of the law. The Supreme Court in Margiotta versus Christian Hospital articulated the standard fairly well. Unfortunately, it seems that the courts have not found their way to following it. There is this reasonable belief standard that predated Margiotta and it has continued on beyond Margiotta, even though Margiotta said the reasonable belief standard isn't the right standard. So what that standard was if you reasonably believe that which you were reporting constituted a violation of law or a clear mandate of public policy, then you were somehow afforded protection. And what we're trying to do here is bring it back so that whistleblowing is actual true whistleblowing. It involves reporting of something unlawful or refusing to engage in something unlawful. And what you have before you is a bill that we, the business community, it's their ideal version of the bill.
Jay Adkins, General Counsel for the Missouri Chamber of Commerce, on behalf of our 3,000 members and their employees, I would echo the testimony we just heard, and the Chamber would go on record in support of this legislation and be happy to answer any questions.